Let's talk about the Competition Act, anti-competitive practices, and how this act protects the consumers. The Competition Act 89 of 1998 aims to achieve a competitive environment that will, among other things, provide the consumers with competitive prices and product choices. The Competition Commission is one of 3 competition agencies established by the Act, which investigates, controls, and evaluates restrictive practices, the abuse of a dominant position, and mergers with the overall objective of promoting and maintaining competition in the market. History has shown that if competition is not regulated, firms will engage in anti-competitive behavior, such as agreeing on prices, allocating customers, and abusing their dominance through excessive or discriminatory pricing. Anti-competitive conduct refers to a conduct by a firm or firms that seek to eliminate or lessen competition between them. Examples include when competing firms agree on what price to charge customers and when. This is collusion, as competitors simply agree not to compete with each other. Or when a firm that dominates a particular market decides to charge customers excessively for a product they have no alternative sources to or substitutes for. Being dominant is not the problem, but abuse of a dominant position is. A firm is dominant if it has a market share of 45% or has market power. The firm is able to control prices, exclude competition, or act independently from competitors, customers, or suppliers. However, consumers should note that a high price is not necessarily an excessive price. In some cases, a firm may go on a buying spree by taking control of other competing firms to remain the only firm providing a particular product. The firm or firms being acquired may be prone to acquisition due to failing or not being profitable. A firm may fail as a result of anti-competitive conduct by a dominant firm pricing below its costs, resulting in the elimination of other competitors from the market. This is like setting a trap for someone and then rushing to their rescue. However, it is important to note that charging a lower price does not in itself mean that a firm is charging below its costs. If unregulated and not monitored effectively, mergers and anti-competitive practices will eliminate competition and create monopolies. Anti-competitive practices and mergers will result in the right of a consumer to choose whom to buy from being limited, if not completely eliminated. Price competition between firms becoming a thing of the past, thus forcing consumers to pay high prices. No incentive for firms to be efficient or more innovative in offering better quality products. New entrants being discouraged from entering the market due to unnecessary barriers created, or the prevalence of anti-competitive conduct in particular markets. Firms having little worry about losing customers since the customer has no choice but to buy. Customer service will be the last thing on any firm's agenda. And if we only had one retail store, the kind of product choice and price difference that currently exists would not be there. The Act enhances consumer welfare by deterring firms from monopolizing industries or colluding to raise prices. It does this by setting out the provisions governing anti-competitive practices and mergers that seek to remove competitors to sustain and improve effective competition to the benefit of consumers. The Commission has the power to investigate and refer anti-competitive practices to the Competition Tribunal for prosecution. If found guilty, a fine of 10% of a firm's annual turnover may be imposed. The Commission has the mandate to prohibit a merger that has undesirable consequences for competition. Although some mergers may benefit consumers in allowing firms to operate more efficiently, others may reduce competition and cost consumers thousands in form of excessive prices and reduce product quality, consumer choice, and innovation. Mergers between competitors may eliminate competition by limiting the number of players. The Commission also conducts information sessions and campaigns to educate consumers and consumer groups about the Act and how it benefits them. Informed consumers will help in the detection and reporting of anti-competitive practices, which the Commission is not aware of. Anti-competitive practices are harmful to consumers. Therefore, it is important that consumers, whether organized or individually, assist the Commission in eradicating them. Consumers are encouraged to be well organized in order to maximize the impact of their involvement in these issues. Consumers, either individually or in groups, can participate in the proceedings of the Commission and the Competition Tribunal. Consumers are often undermined because they do not complain or are afraid to make their views heard on matters that affect them. There are a few organized consumer groups, and this impacts on the extent to which they are able to pursue matters. The rules for proceedings within the Commission grant interested parties the right to participate in the proceedings. In terms of these rules, any interested person may lodge a complaint with the Commission concerning an alleged prohibited practice, be allowed to make written representations opposing an application for an exemption within 20 business days after notice has been published in the Government Gazette, voluntarily file any document, affidavit, statement, or other relevant information in respect of a merger, participate in hearings. Any person may initiate a complaint and does not have to be directly affected by the anti-competitive conduct. The Commission can also independently initiate a complaint against a firm that is alleged to have contravened the Act. A complaint can be lodged by completing a CC1 form available on the Competition Commission website and